Hello, and welcome to the last installment of McDermott's State Privacy Law series, at least until another state passes a consumer privacy law. Now, if you've missed any of our videos, be sure to check them out using the link at the bottom of the screen. In this video, I'll be looking at the enforcement mechanisms of the new state privacy laws in California, Colorado, Virginia, and now Utah. Now, let's start with Colorado, Utah, and Virginia, as the enforcement mechanisms there are all pretty straightforward and similar. In Colorado, Utah, and Virginia, the new consumer privacy laws each expressly provide that they do not create an independent basis for a private right of action. Now, despite this express disclaimer related to private rights of action, we nonetheless expect that some plaintiffs somewhere will attempt to bring unfair business practice or deceptive business practice claims under the guise of these new laws. Now, absent a private right of action, the Colorado, Utah, and Virginia laws leave enforcement in the sole and exclusive domain of the appropriate state attorney general. Now, in Colorado, prior to initiating an enforcement action, the Attorney General is obligated to provide written notification of a violation and allow the business 60 days to cure that violation if a cure is possible. Now, if the company does not or cannot cure the violation in that time, then the Colorado Attorney General can initiate a suit for injunctive relief and/or seek fines under Colorado's Unfair Trade Practices Act, which allow penalties of up to a maximum of $3 million, though that number can be increased at the discretion of the courts. Now, similarly, in Utah and Virginia, the attorney generals must issue a written notice of violation and on there allow a 30-day cure period. Now, after that, the attorney general can seek actual damages to consumers for up to $7,500 per violation, along with injunctive relief. Finally, as you should expect by now, California is a bit different. There are three different enforcement mechanisms. First, the Attorney General has an enforcement mechanism that allows civil penalties between $2,500 and $7,500 for each violation of the CPRA. There's also administrative enforcement by California's new agency, the CPPA, with fines again between $2,500 and $7,500 for each violation. And finally, there is a private right of action in the event of a data breach where the business violates its duty to maintain reasonable security, damages between $100 to $750 per consumer per incident, or actual damages, whichever is greater. So, with these new privacy laws coming into effect in 2023, and with more states on the horizon, now is the time to start preparing your business or organization for compliance. If you need legal assistance, please reach out to one of our global privacy and cybersecurity team members. We appreciate you watching these web series, and we hope that you enjoyed it.